Yes, Akhilesh, can you hear me?
Yes, Milord, very much. Dr. Kruti, we can start today's session now.
Yes, I'm ready. You can start.
Please, ma'am, please.
Jyoti, unmute, please.
Now I am audible.
Yes, ma'am, you are.
Good afternoon, friends. Today is a special day for us. I, on behalf of Adhivakta Parishad Punjab, welcome you all to 4th online lecture of Justice D.V. Sehgal Memorial Lecture Series started by Adhivakta Parishad Punjab. Honorable Mr. Justice Suvir Sehgal, Honorable Mrs. Justice Alka Sarin, all the honorable judges, Learned Advocate General Haryana, Shri Baldev Raj Mahajan, our Journal Secretary Padam Kant Dwivedi ji, senior advocates of the bar, President, Secretary, and all office bearers of Punjab Adhivakta Parishad. Ladies and gentlemen, as we all know, during the ongoing COVID pandemic, Adhivakta Parishad Punjab started this virtual lecture series in the name and memory of late Honorable Justice D.V. Sehgal ji. The series has been started under the able guidance of Shri Baldev Raj Mahajan ji, Advocate General Haryana, and Padam Kant Dwivedi ji, our Journal Secretary. We are blessed with the company of Honorable Mr. Justice Suvir Sehgal throughout our lecture series. Today, we bring you the 4th lecture of the series on the topic of right to education. Related back, in the first lecture, we had Honorable Mr. Justice Suvir Sehgal for introductory session and Honorable Mr. Justice Anil Khetrapal as keynote speaker on the rights of women under Hindu succession. We were blessed to have company of Honorable Mr. Justice Arun Palli on rent law after touching 2 topics on civil laws. We had opportunity to be enlightened by Honorable Mr. Justice Arvind Sangwan on various provisions of NDPS Act. Friends, our distinguished guest for today's session is Honorable Mrs. Justice Alka Sarin, Judge, Punjab and Haryana High Court. Her ladyship was born in New Delhi and graduated from Delhi University with BA degree in political sciences. Her ladyship initially practiced before the Supreme Court and the Delhi High Court. After her marriage, her ladyship started practicing in Punjab and Haryana High Court from April 1991. And while practicing at Punjab and Haryana High Court, her ladyship obtained her LLM degree from Kurukshetra University in 2004. Her ladyship also became Joint Secretary of Punjab and Haryana High Court Lawyer Association. As a lawyer, her ladyship dealt with all type of civil litigations, including family disputes, land matters, rent disputes, cases of medical negligence, arbitration, taxations, disputes, and matrimonial disputes, apart from due diligence investigations. Her ladyship in past had given lectures and presentations on medical legal issues relating to organ donation, laws relating to sexual harassment, child abuse, and women laws. Finally, her ladyship was elevated as Additional Judge Punjab and Haryana High Court on 26th of October 2019. I welcome Honorable Mrs. Justice Alka Sarin to guide us through various provisions of Right to Education Act. Honorable Mrs. Justice Alka Sarin.
Thank you very much. Good afternoon, everybody. It's an honor for me to be here today, invited by Adhivakta Parishad Punjab. I will be speaking on the Right to Education Act 2009. This is a great initiative on your part because it gives everybody an opportunity to learn something every day. I have just one little suggestion. Just don't treat this period of COVID-19 pandemic, where we are all cooped up in our houses, as a time of frustration or non-productivity. Instead, use this period to enhance your knowledge, educate yourself. I have myself taken a number of online courses from foreign universities. Most universities, you would be surprised, are offering free online courses. And you will not get another opportunity to educate yourself. Do it. Enhance your knowledge. Educate yourself. Education enhances your personality. While some of us, most of us here, we take education as granted. We know when we are born and we will be sent to school once we are age appropriate. But for some, education doesn't come so easy. They have to struggle. They really have to struggle to get into a school. They have to struggle to get access to education. We all can't even imagine what it is to not be able to read, write, or even sign our name. We don't only need education for us to get a job, but also to know our rights and to be able to protect ourselves, and most of all, to think for ourselves. Most people are devoid of this privilege. We should consider ourselves very privileged to have been given the best of education by our parents. So education plays a very important role in our lives. And the sooner we realize the value of education, the better for all of us. Keeping in mind these facts, the Constitution itself provided for certain provisions. Article 45 of the Directive Principles of State Policy, as it stood prior to 2002, stated that within a period of 10 years from the commencement of the Constitution, free and compulsory education would be provided. Every state shall endeavor to provide free and compulsory education for children until they complete the age of 14 years. Now, since then, nothing really happened and things continued as they were. The privileged, the not so privileged did get education, but not every child. It was in 2002 by the 86th Amendment that a provision for early childhood care and education was brought about. Article 21A of the Constitution of India was added. It was made a fundamental right, and it provided that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. So this was a very, very important feature. And by adding Article 21A by the 86th Amendment, India became one of the 135 countries to make education a fundamental right. Article 21A came into effect from 1/4/2010. By the 93rd Amendment of the Constitution, Article 15(5) was added. Now, this was yet another very advanced, very far-thinking provision, which provided that the state shall not be prevented by the virtue of Article 19, Clause G and Clause 1, for making a provision for advancement of any socially and educationally backward classes or citizens, or scheduled caste or scheduled tribe, as far as such special provisions relate to their admission to educational institutions, including private educational institutions, whether they were aided by the state or unaided. Minority educational institutions, as envisaged under Article 31 of the Constitution were left out of the purview of 15.5. Article 30, we all know, is the right given to minorities to administer and establish their own institutions. The Right to Education Act was introduced in 2009. This feature, this act, was a very far-reaching act because it was to provide free and compulsory education to all children in the age group of 6 to 14. The main features of the Right to Education Act were: one, that all children must compulsorily be provided free education by the states in the age group of 6 to 14. This further stated that no child would be expelled or corporal punishment would be given. Corporal punishment was banned, in fact, and even board exams up to class 10 were stopped. The children were given a right to be admitted into age-appropriate classes for children who had not been given any education earlier. They were to be admitted into age-appropriate classes, and provision was to be made for them to get elementary education till the age of 14. Another very important feature of this act is that the requirement of date of birth certificate was done away with, and any other document could be used for getting admission into a school. The idea behind this was that no child should be deprived of education only for lack of age proof. Then another very, very important feature of this act has been 25% reservation for the economically weaker section of society. Every private school, aided or unaided, was to make provision for 25% students belonging to the EWS category. The idea here was that one must be able to give inclusive education. What the children are getting in the government schools is not what we call inclusive education. When we admit a child from an EWS category into a private educational institution, there is a different kind of an upbringing that the child is exposed to. It helps that child to grow holistically and to be able to participate and contribute in all respects of life. Inclusive education is how schools were to develop and design classrooms and activities so that all children can participate and learn together. The idea of having 25% children in these schools was that they be not segregated, they be intermingled, they be integrated, so that they can grow holistically, they can learn so much from the other children. And the curriculum was also to be made in such a manner that it was easy for these children to understand. Yet another feature which was commendable about this act was that capitation fees was done away with. There was a ban on charging capitation fee. As parents, we all are aware that schools, some big schools, some small schools, were charging capitation fee, maybe not as capitation fee, but as donations. Now that was something which was done away with. Then it further laid down that there would be no screening procedure for admission. To my mind, that was a blessing for the little children. The kids who were to get admission into nursery were made to start preparing a year in advance for a nursery class entrance exam. They were put through an entrance exam. They were put through interviews, totally uncalled for. This was done away by this act. It also provided various other features, free uniform, free books, etc. for the EWS children. Now, the validity of this act came to be challenged before the Supreme Court, and the validity was upheld in the Society for Unaided Private Schools of Rajasthan versus Union of India, where the Supreme Court upheld the validity of the act and said that the act would apply to all private schools, including aided minority schools, but not to unaided minority schools. Now, what was held not to be applicable to unaided minority schools was 25% reservation. The rest of the provisions were to apply. Now, this judgment was further came up before the Supreme Court and was overruled to this extent that minority aided and unaided schools stand on the same footing, and therefore this provision of reserving 25% seats for EWS would not apply to aided as well as unaided minority schools. The biggest challenge that the Right of Education Act threw up was the reservation of 25% seats for students under the EWS category. Private schools put up various resistances regarding the admission of children under the EWS quota. A tussle started between the private schools and the authorities, primarily regarding reimbursement issues and various other issues. The problem was that a lot of schools, the big schools, felt that they could not have children from the EWS category in their schools intermingled with the rest of the children. And that was one of the factors why resistance was being put up. A lot of parents also felt that children from EWS category should not be intermingled. But one totally lost sight of the fact that these children needed that kind of education. These children needed to be integrated into private schools so that they could also grow up in a holistic manner and be able to live in a world and compete with the other children. In a number of states, what was happening was that when the land was allotted, there was a provision made, like in Chandigarh, there was a specific provision in the allotment letter of the schools who were allotted land in the 1996 scheme. There was a scheme which was floated by the Chandigarh administration for allotment of land to educational institutions. Now, under that scheme, in the allotment letter, there was a clause that there were various amendments to that clause. Ultimately, I think it was that 5% seats are to be reserved for EWS category. The question arose that how is this 5% included in the 25%? Is the reimbursement going to be for 20% or is it going to be for 25%? So this was the issue peculiar to Chandigarh. In Haryana, a conflict arose between Rule 134A of the Haryana School Education Rules, 2003. Now, this rule came to be challenged also in this High Court. I'll come back to the Chandigarh case and I'll tell you what happened. There is a judgment now of this court, which also has settled that part of it. Now, 134A provides that meritorious students belonging to EWS category would be given, there would be reservation for them in schools. Now, after the coming into force of the Right to Education Act, Section 134A was challenged before this court as being illegal unconstitutional, and repugnant to the provisions of the RTA. In Haryana Progressive Schools Conference versus Union of India, the validity of 134A was upheld. Yet again, this matter came up before this court in Satbir Singh Huda's case, where again they said that no, there is no conflict. Now, a wonderful thing which was noticed in that judgment is that in state of Haryana, you see, when we talk about Right to Education Act, it says a child will be admitted in the neighborhood school. Now in Haryana, as per the Haryana government, the private schools have not been labeled as neighborhood schools, and it is the government schools which have been labeled as neighborhood schools. However, that apart, it was also clarified that the reservation would not exceed 25%, including the reservation under 134A. So that part stood settled there. Now, regarding Chandigarh, the matter when it had come up, this came up before this court, and though the issue was different, however, one of the findings which have been given by this court is that clause of reserving students, 5% students, is applicable only in cases where the schools were allotted land under the 1996 scheme and not to schools who were allotted land prior to that. Now, these are the basic features of the Right to Education Act. An offshoot of the Right to Education Act is, since the Right to Education Act did not provide any regulation regarding fees, and fees, as we all know, became a burning issue and still is a burning issue, where authorities, on one hand, schools, parents, are all at loggerheads. So the Fee Regulation Act, Punjab, came up. The similar acts were made in other states, including Haryana. Chandigarh adopted the Punjab Fee Regulation Act. Now, this Fee Regulation Act, besides the other provisions which it has, it basically created a bar of about 8% increase every year. So it capped the increase by schools at about 8%. So the schools were not allowed to increase more than 8%. And in case a further increase were required, there were certain terms and conditions to be complied with. The Fee Regulation Act also is under challenge in this High Court and is pending. Both the Punjab Act as well as the Chandigarh Act are all under challenge. However, there is no stay in it. So as of today, the cap of 8% and all the other provisions stay. Now, during this period of the COVID pandemic, especially the period in March, April, when we were under curfew, there were no classes being held. And a lot of people did lose their jobs. There were financial constraints felt by a lot of parents. And again, an issue rose regarding the fees. How much was to be charged, whether fees was to be charged, whether annual charges could be charged, whether admission fees could be charged. So all these various issues again came up. And keeping in view the current scenario, the loss of jobs, the financial hardships which are being faced by parents, the matter once again came up before this court. In fact, the authorities had taken out a notification saying that the schools were not to collect certain fees. That notification was challenged before this court. in Independent Schools Association, Chandigarh versus State of Punjab. In this case, the parents were also represented. And by very detailed judgment, the learned single judge has permitted the collection of fees irrespective of whether the schools were offering online classes during the lockdown period or not. They were held entitled to the tuition fees. However, they were to endeavor to impart online and distance learning so that education is not adversely impacted. There were other directions given. Now, let me just give my point of view also on this. There is a site which is put up by the schools, there is a site which is put up by the parents. The parents say that we are facing financial hardships, the schools are not conducting regular classes, and therefore fees should not be charged. However, look at it from the other side also. We cannot lose sight of the fact that there are teachers who are conducting those classes for your children. There are teachers who are on the rolls. There are people who are on the rolls. There are class 4 employees. Their salaries also have to be paid. So keeping all these factors in mind, this judgment was given. Now this is pending before this court. It's been challenged in an LPA and it is pending. In a matter arising out of state of Punjab, in another LPA, the division bench of this court very recently, probably maybe some time ago, has said that the tuition fee would be charged only if students are offered online classes on day-to-day basis during the lockdown period. However, the staff and the teachers, whether permanent or contractual, shall be entitled to their regular salaries, which they were getting before imposition of the lockdown. Now, what are the suggestions that one can think of to make RTE more effective? Personally, my view, right from when the Right to Education Act was enacted, in fact, the then HRD minister had held an interaction with a lot of people, and I happened to be present there, where they were asking for suggestions before the implementation of the RTE Act. And one of the suggestions that I had given that time also, and I strongly feel about it even today, is that the RTE talks about 25% reservation for EWS category. A school has 100 seats for the general category. In that, they have their own seats for alumni and so forth and so on and so forth. Now, when we talk about 25% reservations amongst those seats, we are actually dislodging 25% of the students from the general category. My suggestion that time also had been that, see if it's possible, instead of taking those 25% seats from the general category, because where are those children going to go? Where are those 25% children going to go? They want to be educated in private schools, but they're now going to be dislodged. Though this is a brilliant effort on part of the government to provide for 25% reservation. However, my personal view was that this should be in addition. So if you have 100 seats, make it 125 seats so that 25% more children can be accommodated. The other factor which one needs to keep in mind is that the Right of Education Act is dealing with only children up to the age of 14 years. So what thereafter? what happens thereafter? Can these children be left in a lurch? Some provision should be made, according to me, for these children to be able to take their education further. For children who are interested and who are doing well in their respective chosen subjects, provision should be made to permit them or to give access to them for future education. Children who are not so inclined towards education, but who have been imparted the basic elementary education, they should be given some kind of vocational training so that they can also get some kind of employment. They can be self-employed or they can get some sort of employment. We can't leave these children in a lurch. What we need to understand is that today we educate these children in a private school. Now, these are views of some of the counselors I had interacted while I was an advocate. I'll share them with you all. So, these children who do manage to get into good schools benefit a lot. But at the same time, they belong to, say, a small colony or something. They become outcasts there. In their own schools, not all children welcome them with open arms. So we really need to put on our thinking caps as to how best we can make the system work to make these children live their lives comfortably and be happy in their environment. It's a very, very difficult situation, and a lot of effort needs to be put into this, not only by the government, by the schools, but by the parents and by the children themselves. This right to education policy can be a success in India. The government has laid down the framework for it. Now, how we go forward with it depends on the schools as well as us. How do we want to take it forward? How do we tell our children? How do we say that our children we should encourage, in fact, our children that when there are children from the EWS category, they are integrated in their class, they should welcome them with open arms. The same, a little off the topic, is even for children with special needs who have now been integrated into the mainline schools. They have to be welcomed with open arms to make them feel comfortable in the environment and be able to grow along with the other children. The midday meals is another very important aspect which is being taken care of by our team. The children belonging to the EWS category are being given midday meals in most schools. Yet another point which I would like to touch upon is that the severe punishment which was meted out earlier to students. We have all been students. We have all been through it. I also remember our school. There was no holds barred. If we made a mistake, we were punished accordingly for it. But now times have changed, concepts have changed. And severe punishment, I think also the thinking has changed. More importantly, the thinking has changed. And the children feel humiliated if they are scolded in school or if they are reprimanded in front of the others. And therefore, this act and the provision in this act for banning corporal punishment is a very welcome step. We read every day some child reprimanded at home, some child reprimanded at school, takes an extreme step. So this was a very, very important feature. Along with this, Counselors have also been made, the presence of counselors has also been made mandatory in schools, which is again a very welcome step. We, as children, lived in a different era where we were carefree, we had no cares in the world. Children now seem to be carrying the responsibility of the world on their shoulders. They seem to be very stressed out. They seem to be very stressed out about their future. They seem to be very stressed out about their images on social media. They seem to be very stressed out about everything. So counselors play a very important role there. Now, recently, Akhilesh, please tell me when my time is up.
No, no, Manoj, may continue. Nothing with regard to time, Manoj. Because everyone is, Manoj, the kind of commentary you're getting is one. Please, Manoj, may continue.
So making right to education a fundamental right is a very important step for every child. Despite this act coming into force and despite 21A being added, Article 21A being added as a fundamental right, do you people think, or do we people think, that this has really been effective? No. Every day when you go out on the street, you go out in your cars, on the traffic lights, you will see these little children begging, selling things. It's not for them. That's not the place. Their place is in a school. Their place is besides the other children. They should be playing, they should be studying. That is what they should be doing, not looking at earning a livelihood, not looking at maintaining families. So it has to be a joint effort, not only by the government. Government has done its part. Government does its part all the time. It comes out with the act, it comes out with the provision. But the laws have to be followed by us. We, as the people of India, have to follow these laws. We have to take a proactive step. We can't just say all the responsibility of putting the provisions in place is with the government. No, we are equally responsible as citizens. We have to play a proactive part. We must ensure that these children, 25% children, get admission in schools. We must ensure every child is sent to the school. How many of us have ever stopped at a red light and asked these children, why are you standing here? Shouldn't you be in school? Are you going to school? Do you have access to education? None of us do it. But time for us to do it. We should make this effort. In furtherance to providing education and making education more holistic, the central government has now come out with the National Education Policy. This education policy also has various features, including providing of preschooling education. You see, our children, or say the more privileged children, start going to school now at the age of 2.5. So they have a head start. When they go into the main school, they have a head start because they've had, school starts for class 1. The age appropriate, the age which is appropriate for class 1 is, I think, 6 years now. So 6 years. These children from 2.5 to 6 years have that head start. Children coming from EWS categories or children who have been deprived of education and straight away come to say are admitted to class 1 don't have that head start. They don't know how to hold a pencil. They don't know how to write ABCD. So for them, this provides for preschooling. The National Education Policy talks about 12 years of schooling and 3 years of Anganwadi and preschooling, which is a very important feature. We, sitting or placed where we are, we don't realize the importance. We don't realize the importance of education because we all take it for granted. Ask a person who can't think for himself, ask a person who can't sign. He will tell you what the value of education is. When this child of, say, 4 or 5 years comes to the school, he has children all around him who probably are speaking by then fluently in English, who have been made aware of, say, their hygiene, who are aware of table manners, who are aware of various games. They can read ABCD, they can say their numbers, they can write their numbers. These children are not there. They've missed out on all this. And therefore, preschooling for them is also very important, which the National Education Policy now takes care of. They've also introduced in the National Education Policy teaching coding in school as part of the 21st century skills and school education as part of the curriculum. This is a very important feature. Today, as we all know, and this pandemic has taught us that we are all actually working through virtual classrooms, we're working through virtual courts, and the importance of computers. So teaching children and incorporating in the curriculum itself would be very beneficial for them. Computers, in fact, is playing a major role in all fields. I don't think there is any area where computers are not being used today. Also, the education policy has given us comprehensive set of recommendations for promoting online education consequent to the rise in epidemics and pandemics in order to ensure preparedness with alternative modes of quality education whenever and wherever traditional modes of education are not possible. That has been covered. Now I'll give you a little pointer here. With this, what will happen is that there are far-flung areas in the villages where physical education or physical schools are not possible. But with this, if we can have online education for them, if we can have some sort of a system, maybe put up a big screen and have education for them, at least they will be able to have access to education. Well, so that's about all for about the right to education, the fee issue, and the national education policy. So if any of you have any questions, I could answer that.
Please, Manoj. Well, it's a wonderful to have you on the session. You have explained the act in the most simplest manner, not as a. I think that people will not only be benefited as a lawyer, but also as a parent. Also, we have come to know a few things with regard to that. Manoj. Because few of the participants have posted some of the questions. If Manoj may permit me, I start off it.
Yes, yes, please.
Please. Well, the first question has been asked by Mr. Dinesh from Bathinda. He asked that can unaided school make separate portion or classroom for EWS students or same classroom is compulsory for EWS students? What are the provisions for such partiality, if any, in comparison to the general student?
The RTE makes it mandatory to integrate the children. You cannot have separate classrooms for them. The whole idea of the RTE was that these 25% children will be integrated in the mainstream. Mainstream means with the other children. That is the whole idea, and that is the way they will grow holistically. So if some school is doing that, there are provisions. You can ask for disaffiliation, CBSE affiliation, ICSE affiliation. You can write to them. You can write to the government. There is a no objection which is given by the government. And then affiliation is given by CBSE. So you can write to the authorities and one can complain about that.
Thank you, Manoj. Manoj, the second question has been asked by Mr. Prateek Mahajan. He says that in Punjab, Right to Education Rules 2012, as per Rule 7, there is a government school. If there is a government school in neighborhood, the private school need not admit EWS students under 25% quota. Don't you think that the provision is illegal and against the spirit of Section 12 of Right to Education Act?
You see, the whole idea here was to educate children in a neighborhood school. Neighborhood, I'll tell you why. Why the concept of neighborhood was introduced. So that the children don't, and a lot of children don't have conveyance, right? So the idea was that they can walk to the schools. Like I told you in Haryana, in most schools, it's the government schools which have been labeled as the neighborhood schools, and private schools have been left out of it. So to my mind, this would not be an illegal provision. It depends on the government. If the government has enough facilities or has enough schools, they think that they can cover up and they can provide education to all the children in their own government schools. Nothing like it. But yes, it will be very beneficial for the children to be able to go to private schools. So I think, Akhilesh, there is a issue with this connection.
Please, Suresh. Worship, there's a question. I will ask the question next.
Yes.
There's a question from Mr. Lab Singh that if we find any child begging or selling anything in the city, then if we inform to the deputy commissioner regarding that why the children are not sent for education, then what is the remedy if the deputy commissioner or the authorities do not act? Because it is the duty of the state as well to provide education. So we see begging children.
It is a duty of the state, but it is also simultaneously, like I said, this has to be a joint effort. So you can't just see the government, it can't possibly say we have, say, take Chandigarh. It's not a very big town. But if you say it's the duty of the government to take all these children who are on the street and admit them in the schools, it's not happening. He may admit them. It is this is where the parents play a role. The parents of those children also need to be told. So the way to go about it would be to really, maybe as an NGO or as concerned citizens, go to these colonies, speak to the parents, tell them the benefits of educating their children, encourage them to enroll their children in schools, tell them about their rights, tell them that they have a right to get their children admitted. 35% of children are admitted into private schools. Tell them about their rights, make them aware. This is where I started my lecture with this, that education, where does it play a role? We don't know about our rights. I don't think the DC, I don't think there is any provision. At least I have not come across any provision where the DC doesn't take any action. Something can be done.
Basically, role of NGOs would come into picture in this scenario, I guess.
Definitely, NGOs definitely comes into the picture where, again, adult education plays a role where you can go and talk to these parents and tell them the advantages of educating their child. They don't. You see, for a lot of these people, they are living hand to mouth. So they are dependent. If they have 5 children, they're dependent on the income of those 5 children. They don't want them to go to school. They need to be educated. They need to be told that how education is going to better their lives. I hope that answers the question.
Yes, please, Suresh. Okay.
Please, Milos. Milos, the next question is that how is the new education policy 2020 is being integrated with Right to Education Act? Question asked by Mr. Saravjeet Khurana, Milos.
See, again, Right to Education Act lays down has certain provisions. The education policy is more for the schools, more for the functioning of the schools, more on the emphasis on the curriculum, more emphasis on is how the classes are to be carried out. It talks about multidisciplinary universities instead of having just one stream in a university. So it's more on the curriculum. I don't think there is any conflict as of from what I've read of the national education policy. It's a lengthy policy. I haven't read the whole thing, but it deals more with the functioning and the curriculum which probably the schools and the universities need to follow, rather than touching upon any of the provisions already there in the RTE.
Please, Milad. Milad, the last question for the day would be, is there any provision under Right to Education Act to push schools to update curriculum, focusing more on practical aspect rather than the theoretical aspect, Milad?
You see, some time ago, they had started with, there is no such provision there. But what had started was continuous comprehensive evaluation. Now, when they talked about continuous comprehensive evaluation, that was a more holistic thing. It was a more wider curriculum where not only academics, sports, your other co-curricular activities, everything was evaluated and you were given marks on that. So that was a broader kind of a thing. You see, the act itself does not say anything, but what is the requirement of the day, what is needed is to have a curriculum. Every child, like all five fingers are not equal, every child is not equal. So some may be very brilliant in academics, some may be average in academics, but brilliant in sports. So we have to see and devise a curriculum which looks at a more holistic growth. I really personally feel children should not be only evaluated on academics. There, every child is got a different mindset. Every child thinks differently. One may be brilliant in maths, one may be brilliant in science. So we can't equate children. So we need to have curriculums which are basically more broad and which looks at a holistic growth of a child. There is nothing in the RT regarding that.
Please, Milad. Milad, thanks a lot for answering all the queries. Now I request Advocate Neeru Thareja to grant a vote of thanks for the day.
Thank you, Mr. Akhilesh. Good afternoon, everyone. I, on behalf of entire team of Adhivakta Parishad Punjab, extend my most sincere thanks to Honorable Justice Alka Sarin ji, our keynote speaker of the day, who graced this platform and enlightened us on a very important and hot topic nowadays, that is right to education. It is of great importance as a parent and from professional point of view. In addition to this, Justice Sarin had answered all the queries in a very satisfactory manner, ma'am. I also extend my thanks to Honorable Justice Suvir Sehgalji, who to remain with us in the entire session of the webinar. His presence is a great encouragement for the entire team of Adhivakta Parishad Punjab. Thank you, sir. I also thank Shri Baldev Raj Mahajanji, Advocate General Haryana, who is always there for guiding us and put every effort to make every session a big hit. I also thank Shri Padamkant Dwivedi ji, our Zonal Secretary, Shri Rakesh Gupta ji, our worthy President, and Shri Akhilesh Vyas ji, our General Secretary, Adhivakta Parishad Punjab. I would be failing if in my duty if I do not thank to each and every member who joined us on our Zoom and YouTube channel and made this session successful by sparing their precious time. Last but not the least, I would like to thank our technical team. Thank you, everyone. It's my humble request to everyone, please do subscribe our YouTube channel and join us again on next Sunday with a new informative session on the same time, same channel. Once again, thank you so much, ma'am. Thank you for sparing your precious time.
Thank you. Thank you very much.